thank Sarah Moberg and Fiona Room, who have been trying mightily to get this going. You really have provided a lot of pleasure to make this lecture series possible. So thank you to Sarah. I'm Susan Zesch. I'm the Executive Director of the University of Chicago Human Rights Program. This program tonight has been made possible by an endowment from two supporters of the Human Rights Program, Richard and Ann Tozer. About a little over a year ago, they gave the university a $1 million endowment to establish a chair for a distinguished visiting human rights professor. Their intent was to bring to campus outstanding human rights practitioners and outstanding human rights scholars to become part of the campus and the broader community, to teach students in the college and to help us maintain an interesting and open dialogue on this campus about human rights, both domestic and international. I can't think of anyone better than Albie Sachs to be our first closing professor. He is a wonderful combination of both a distinguished intellectual and a dedicated practitioner of human rights. This lecture series, which are taken from Justice Sachs's most recent book, The Strange Alchemy of Life and Law, compile his experience as a sitting judge. He has a rather unique experience. He has spent 15 years as a judge on a constitutional court, adjudicating cases based on a constitution which he helped to write, the first democratic constitution for South Africa. So if, in U.S. legal parlance, we want to talk about the framers, or as Justice Scalia has mentioning, original intent, Albie in the South African context is certainly capable of understanding and explaining what the intent of the framers were. He's being one of the framers himself. His lecture series also is intended to bring questions to the fore that are important to us in the United States today. And those questions were fairly, well, not necessarily thoroughly examined, but brought out in the discussion over the nomination and confirmation of Supreme Court Justice Sonia Sotomayor. And those questions center on who are judges and how and why do they make their decisions? How does adjudicating combine reason and passion? The next set of lectures, there are four more lectures in this series, will be every Wednesday in this room through February 3rd. The topics will be next week, punitive justice and restorative justice, social and economic rights as fundamental human rights on January 20th. January 27th, does the law have a sense of humor? February 3rd, the secular and sacred, the right of same-sex couples to marry. We are sending around a sign-up sheet, so if we decide we have to move to a bigger venue, we will have all your names and email addresses, because we have no idea, thanks to the cooperation of our many friends on campus and in the community, how you all heard about this lecture. It went out on lots of lists, and we're very pleased to see you all here. As for copies of Justice Sachs's book, we are hoping that by next week, or possibly the week after, Oxford University Press will have sent us the box of 50 or 60 or however many they have promised, so that Justice Sachs, after the lectures, when the books are here, will be able to sign copies of the book for people who wish to purchase it. I think that it's a tribute to Albie Sachs's friendship with many, many people in Chicago that he's willing to come here in January. It's a tribute to our affection and tremendous respect for him that all of you have come out on a really bitterly cold night to give him a warm Chicago welcome, and I'm pleased to welcome Justice Albie Sachs.
I can only explain it as an addiction. I was here last January, the January before, and the January before. It can't be voluntary. And just before I start my presentation, I always love it coming from Africa to part of world technological innovation. If something here doesn't work. So thank you guys. We're getting ready for the 2010 World Cup. Spectacular, beautiful stadiums and airports that are going to astonish people when they get there. So thanks for something that's not working here. I was 29 years old teaching law as an exiled lawyer at Southampton University in England when I discovered I was a terrorist. The knowledge came to me when I thought about attending a conference at Yale University on contemporary Southern African history, 1974. And I learned that I would have difficulty getting into the United States to attend the conference because I was a member of the African National Congress, whose best-known leader, Nelson Mandela, was locked up on Robben Island as terrorist number one, seeking to overthrow the state by violence. Fortunately for me, the lobby group in Washington against apartheid turned out in that period to be just that much stronger than the lobby group in favor of the apartheid government. So on Monday I was a terrorist, and on Tuesday I was no longer a terrorist. And I got my visa. We didn't enjoy being called terrorists. It wasn't simply because it was a nasty name. The description of being a terrorist in South Africa had consequences, very severe consequences. We would be locked up without trial, thousands of us. And the justification was as enemies of the state, as terrorists. The authorities had not only the right but the duty to pursue us relentlessly. And so I, having defended many people who were my clients, themselves were locked up, detained without trial, found myself one day in detention, solitary confinement. The law used was called the 90-day law. It gave police authorities the power to detain anybody whom they believed might have information dealing with terrorism and similar and very widely defined offences for 90 days. No trial, solitary confinement, no access to lawyers, to family, to anybody. And so I found myself in effectively a complete cube, on the floor, staring at my toes, staring at the wall, staring at the wall, staring at my toes, staring. 5 minutes, 10 minutes, half an hour, 1 hour, 90 days to go. I tried to think of activities to make myself feel a person. And one of the tasks that I set myself is to remember the states in the United States of America. And I would start with the A's, Alabama, I used to say to myself, Arkansas, Arkansas, work my way through. I wasn't even sure how many there were. I knew it was about 50. And I think the biggest total I achieved was something like 47. I wouldn't like to mention which of the 3 states that I couldn't remember. But I couldn't even be sure which states I'd already thought of. I couldn't write down the names. I had 10 fingers then, and I would run through the 10 states, and another 10 and so on. And then I started singing. I wanted to hear my voice. And I would go through the alphabet. And I would start with always. Because Charmaine, those of you around in 1964 63 will remember these were some of the hit tunes of 63. Daisy, all the way through the alphabet. I cheated a bit with X, so I went deep in the heart of Texas. and my favorite very quickly became Always, which I gave my own words to. It's better with the microphone. Just have to imagine. I'll be living here always, year after year, always, in this little cell that I know so well. I'll be living swell, always, always. And then I would swirl around and be amused at the fact that Noel Coward, playwright of upper middle class manners, taking a tune, living Berlin, was keeping up the spirits of a young freedom fighter in South Africa. I'll be staying in, always, keeping up my chin, always, not for but an hour, not for but a week, not for 90 days, but always. And so the days will pass. The 90th day, I'm wondering what's going to happen. The police come to me, they give me back the suit I've been wearing, my tie, shoes with shoelaces, my watch. You're being released. Go down the stairs, session commander, very cheerful with me. Am I really being released? Yes. You're free, he says. I get up, I walk out of the police station where I've been held, and as I reach the door, one of the interrogators approaches me, big smile on his face, with his hand out, says, I'm placing you under arrest under the 90-day law. You have to touch the suspect. When you arrest the suspect, you touch me back. And the right arm again. The right arm. Take away my shoes with shoelaces, my tie, my watch, and back in the detention. That was the first detention, because I was alleged to be a terrorist. 2 years later, I'm back in detention again. And this time there's a squad down from Johannesburg, headed by the famous and notorious royalist Swanepoel. And they're much tougher. And they're banging on the table, making a noise for 10 minutes, and then total silence for 15. And then a noise again, and then total silence. And it happens through the afternoon, through the night. They give me something to eat, and I see a kind of half smile on their face. I realize afterwards there's something in the food. After midnight, through into the morning, the rage, shouting, and then total silence. It just goes on and on and on. I feel my body getting more and more tired. My body is fighting my mind, fighting my will, and I realize I'm going to Paris. After that realization, I stay on for a while, and then I just crumple and fall onto the floor. I never forget those shoes. Suddenly, all of them, they're working in relays. They're all there, black shoes, round my head. Hearing the voices speaking, agitated, can't make out the words. Water pours down on my face, arms are lifting me up, fingers are prizing my eyes open. I sit for a while and then I collapse again, and the shoes again, and the water again, and and lifting me up. And I realized that they are destroying something in me that resisted completely in the first 168 days. The worst moment of my life. Something that remains with me today. Everybody who's been in solitary confinement comments. I met somebody who'd been detained during the Mussolini period in Italy. He said, you never get over it. There's always something different, some kind of loneliness, something strange that you carry for the rest of your life. And that's because I was being a terrorist and treated as a terrorist. The ordinary principles of the rule of law, access to the court, right to have legal counsel didn't apply, they were wiped away. That's power invested in government and the police authorities to decide how long I should be detained and all this involvement. I remember at one stage making a vow to myself. A strange thing happens. You imagine yourself in power as a way of dealing with the humiliation, the isolation, the loneliness, the strangeness of not being with other human beings. And the vow that I made to myself was if ever one day I'm in power, I will never do these things to people like they do to us. That no human being should behave like no human being. I'm released eventually, going to exile. I worked in the United Kingdom, with a PhD at Sussex University. I ended up in Mozambique, newly independent Mozambique. And I'm working there with the joy of a newly independent country close to Africa. And the joy of being involved in constructing, building. And we spent all our years fighting against to bring something down. It was almost voluptuous to be involved in a program of creating, healing, something like that. And we are debating the question of terrorism in our ranks, inside the agency. And that was the period of isms. There don't seem to be so many isms around. You remember the isms. Not only the communism, socialism, capitalism. Some isms came from China, mountaintopism, or something you didn't want to be accused of. There were all sorts of isms. And terrorism was one of them. And we were against terrorism. One of those isms that you denounced, but you didn't identify yourself. And I can recall in the late 60s, early 70s, when planes were being hijacked to draw attention to the cause of Palestinians. Many of the members of the ANC were saying, what's wrong with the leadership? Why aren't we doing this? Why are we so gentle and so careful? Huge attention is being paid to their cause, and people are ignoring us and stuff. And we had very intense debates in our ranks. And I remember how strongly and forcefully people like Oliver Tambo, who was the leader of the ANC in exile, made it absolutely clear, we in the ANC are against terrorism. And it was partly for obvious diplomatic reasons. That we're being projected as terrorists by the white racist minority regime. If we go in for terrorism, then we are justifying the repression. We make it easier for them to get sympathy from the world, saying, well, if they get into power, they start off hijacking planes, now they're going to murder all of us brothers and sisters. So there were strong diplomatic, practical reasons for not engaging in war. But the real reason I believe, particularly for people like Oliver Tambo, was much more profound than that. It was partly that we would never have a country. The minute you start attacking civilians, you're going for a race, for a nation, for people who are who they are, indiscriminately. You can afterwards put up the buildings again that have been destroyed. You can grow food on the farms again. But the ravages to the mind, to the soul, to the personality, can take generations and generations. And we wanted a country. We wanted a country for all. And I felt it so strongly with OR, over the time of OR's reporting, that the whites never had the vision, the generosity, the openness, the sense of truly deep fairness to embrace the whole South African nation. They always felt different from, superior to, alienated from, needing to be in control of the black and gold. And in his heart, his spirit, was very much, we African people who've known so much suffering, so much hardship, because we are who we are. We have the vision. We have that spirit of Ubuntu, of togetherness and openness. In his case, a very earnest Christian. We have the philosophy to embrace everybody. And we can show, we can prove that black and white can live together as equals in life on the basis of full rights for everybody and mutual respect going everywhere. But I believe in his case it went even further than that. It was saying, who are we? What are we fighting for? What motivates us? The minute you convert yourself into an instrument of death, you lose your own humanity. The minute you start killing indiscriminately and saying they all belong to that group, and as such they are all guilty, they are all targets, they all deserve what they're getting, you're not only destroying people out there, you're destroying the very heart, the essence of the cause that you are fighting for. So we were anti-terrorists, and this made the fact that we were being locked up as terrorists, we were being denied visas as terrorists, even more invidious and even more offensive. There were constant debates. Every time there was a massacre in South Africa, black people shot down, protesting, and people like Steve Biko were murdered in detention by security police. The pressure now to retaliate grew. And we had a conference in 1985, a small town called Kabwe in Zimbabwe. I remember so vividly, Zambian troops surrounded the hall in which we were conferring, in case there were commando raids, to take out the delegates and the leadership of the ANC and so on. And one of the issues we were debating was the question of, should we change our tactics? Were we holding ourselves back by repudiating attacks which could involve civilians in South Africa? Were we delaying the onset of freedom? And I remember on one occasion, King Sabato Dalindyebo, we called him the Comrade King, exiled because he refused to be a compliant stooge of the apartheid setback. And he addressed the conference. And he spoke in Hausa, and people like myself, a small number who were culturally backward because all African people had to learn the languages of the whites, we didn't have to learn the languages of the majority. He spoke, addressed the people in Hausa. And he was speaking in a very animated way, and when he finished, the audience were laughing. Translation took place afterwards, and this was the story. He said two men are fighting. They're very angry with each other. And their wives are urging them on. And the wife of man A says, my darling husband, you are much stronger than D. You can easily beat him. But he is messing you up. And that's because you are using one arm, one hand to hold up a blanket to cover your nakedness. Drop the damn blanket, fight him with both hands, and you'll smash him up. And that's what everybody laughed. So when we heard the translation to English, a few minutes later, we laughed. And what he was saying through the story was the ANC is restraining itself unnecessarily. It's worried about what people would say. Drop the damn blanket, go for them. I would have, if I felt to in a smaller group, stood up and said, Comrade King, philosophy of the ANC for many years has been and gone into a long disposition about why terrorism would undermine the people's struggle. But the African audience had a different response. They just laughed quietly. We hear what we're saying, that's not our policy. We move on. And we went on reaffirming the ANC tradition of not using terrorism through this, at this particular conference. Not long afterwards, I got a summons. I was working in Mozambique. The telephone rings. It's OR here with the Tambo. We asked after the health, the work that we're doing, the situation in Mozambique, and wondering why is he phoning. And he says, we have a problem here and we would like your assistance if you can get away. And I still remember he said it so sort of politely, I know that you're doing important work there, it might be difficult. If it helps, I can ask President Samora Michel to release you for a period. Now what I appreciated so much was I used to get a fax. You remember faxes? Came so slowly through the machine. And the fax would say, Comrade Albie, there's a conference in Greenland, and it's Tuesday. Be there, prepare a paper of 30 pages. Here's the president of the organization saying, could I possibly manage to understand that problem? Of course, when someone speaks to you like that, you want to say, take me. So a week later, I'm in Lusaka. Go to the office. I'm wondering, what is it about? And I recall he had a rolled-up newspaper, he was spotting flies. I don't know why, it just struck me as so incongruous that the president of the Premier Liberation Movement in South Africa, living in exile, is swatting flies. You know that he should have had somebody else swatting flies for him. And he wasn't even conscious of it. So he's swatting a fly, he asked after my health, everything's style, how things are going in Mozambique, and I'm still wondering, what is it? And eventually he says, we have a problem. As you might know, the authorities of Pretoria have sent a number of people to try and destroy the ANC. And we captured them, and we discover we don't have any regulations dealing with how to treat captured prisoners. I would imagine the Democratic Party might, some people might love to have regulations like that, but the political party doesn't have clause so-and-so, rule so-and-so, what to do with captives. The ANC constitution dealt with electing the leadership and the meetings and the philosophy and policies, structures, branches. It didn't have any regulations dealing with captives. And causing some problems, he said. And it must be very difficult to get proper regulations. So in my confident way, I said, well, it's not so difficult. We've got international norms and standards, no torture, no cruel, degrading punishment or treatment. He said we use torture. He said it with a bleak face. I'll never forget that moment. We use torture. And he really wanted me, as an experienced lawyer, imbued with the philosophy and policy of the ANC, to respond. Is it permissible to use torture? We'd be dealing with people who'd been sent to destroy the organization. It wasn't dealing with dissidents, it was dealing with serious threats to blow us up, to poison us, to make confusion, to spike the ammunition that was being used. What should be done? I'm just grateful for a minute. I'm going to leave the chair. So I was asked to draft what was called, prepare a draft, what was called the ANC Code of Conduct. In effect, it was a statute for the organization dealing with criminal law and criminal procedure for a liberation movement in Brazil. We didn't have courts, we didn't have a police force, we didn't have judges, we didn't have prosecutions, we didn't have defense lawyers. But we had to find some way of dealing with all the different crimes and offences that were being committed. And the basic structure of the criminal code was to create 3 tiers of offences. The one would be the sort of person who comes drunk to a meeting, is abusive, insulting, a nuisance, interrupts. You don't use the full might of the organization's law. That's got to be resolved, those sort of questions, by the branch, to find their own political ways of doing it. Then you've got the kinds of cases where people stab, drive a car drunk, smash it up, steal money from the organization. They are serious. They're serious in any society. They're particularly serious in a liberation organization where the integrity and honesty is fundamental to sharing their problems. And then the highest tier are people who are trying to destroy the organization. Maybe physically to kill the leaders and to create mayhem. And you have different structures for each of those. For the middle structure, you have district tribunals, and the penalties couldn't be too severe, but it could be being dismissed from a position, being asked to do useful work, things of that kind. And then detention for those facing the 3rd level of serious offences. And we established we didn't use the word prosecutor, a presenter. The charges had to be laid, evidence brought. There had to be a tribunal of people. They weren't independent in the sense that they were all being from the ANC, but not people directly involved in a particular offence concern. And a series of penalties and defence counsel being provided from ANC lawyers, legal people, and an appeal possibly the most important legal work I've done in my life, was drafting that code of conduct. And we discovered afterwards that in fact, enemy personnel were being sent to Angola, where the ANC had camps, had been captured, but were being treated in an abominable way, a shameful way. Their rights as human beings were being grossly denied. While the Tamil, the other leadership had ordered an investigation, the people had reported that it wasn't just a rumor, but these things had happened. I only discovered the details after I got back to South Africa when these reports were revealed. But now I understood why it was necessary to have a code of conduct. The code of conduct is presented to the Conference at Capital. Again, it was part of Oliver Tambo's political style. The new president could have proclaimed, this is our code of conduct. But that wasn't the way he did it. Because it should come from the movement, from the organization. People should internalize, debate, discuss. So all the branches discuss the issues before. And there was no problem about the code of conduct generally. But there was only one issue that required specific determination. Should what is called intensive methods of interrogation be permitted in emergency situations? And that issue was put to the conference. So here we are, surrounded by Zambian troops, and we are discussing, if you like, the fundamental human rights of people who've been captured and been sent to kill. I've presented the report. I'm sitting up on the platform, really curious to know how the delegates will respond. And one by one, they came up onto the platform. There's a microphone that worked. Truly powerful were the young soldiers from Mponto, where Caesar. They didn't even know their real names. They were their names. I've never met them. They were in Angola. I was in Mozambique, the other side of Africa. And one by one they said, no torture. The ANC doesn't use torture. I still remember the one young guy saying, we are fighting for life. How can we be disrespectful? It was so moving. And I felt overwhelmed. It was so easy for me, a lawyer from a relatively privileged background, I can stand up for these principles of abstract. Here was somebody in the front line willing to give his life directly in combat and very distance with people. And he was saying, we are fighting for life. How can we be against it? And people who speak about the miracle of South Africa afterwards, as though it was just the wonderful Mandela meeting a benign and wise locality, leave out these principal factors in our history that already in the freedom struggle itself, we had felt justice has to be in our hearts, in our minds, in the way we do things, if we are fighting for justice. So we had avoided terrorism, and we created the foundation for a Bill of Rights in the new democratic South Africa, because we had in effect a Bill of Rights for the liberation movement, maybe unique in the world. Even before we were able to return to our country and get it was released and negotiate the new constitution. I wasn't in the armed struggle. The armed struggle came to me through state terrorism. I'll deal with this a little bit in this presentation. I just wish to point out, however, that when I was growing up, I was just one of thousands and tens of thousands, and maybe hundreds of thousands of people throughout the world, maimed by, killed by state terrorism. State terrorism doesn't justify non-state terrorism at all, but it's at least equally abhorrent, if not more so, because the state is using all its power not only to destroy people, to make people disappear, to murder, to terrorize populations, to deny them basic fundamental rights. It's using its power to control information, to deny, to hide, to disinform, and to lie. So sometime later, in a hospital bed in London, I'd been moved from hospital good to me, I'd like to say, in case a further attempt was made on my life through the use of poison. I thought, poison? Count. We discovered afterwards that poison was being used, that it had been used, it was being used to assassinate people, that the security people said I should be removed, possibly saved. And I'm lying in the London hospital. They didn't want the name of the London hospital to be given because it would give away where I was. So when I wrote about it, it was the London hospital that didn't want its name to be revealed. And somebody from the Scotland Yard came not to persecute me, but to protect me. And I'm having to get used to that situation where the police on my side trying to save my life. And I remember at about 4 in the morning I would wake up. It's still dark, summer is coming, and I would feel the pain. It was a time when the painkillers were wearing off before I got good painkillers. And there wasn't the people buzzing around and activity and the nurses attending and looking after me and so on. I'd be completely alone. And I would sing to myself again. It's me, oh Lord, standing in the need of prayer. It's me, oh Lord, standing in the need of prayer. It's not my brother nor my sister, but it's me, oh Lord, standing in the need of prayer. And I'm feeling I'm really alone. And I'm singing. And it wasn't an accident, what we used to call the Negro spiritual, to give me a sense of comfort and consolation. And one day I received a note from a friend of mine, Bobby before. His traveling name is traveling. Bobby said, "Don't worry, Comrade Albie, we will avenge you." And I thought, what does he mean? We're going to cut off the arms of South Africans, we're going to blind people in one eye. And I thought, if we get democracy in South Africa, that will be my soft vengeance. Roses and lilies will go out of my arm at the same time. I don't think we talked about that. After I came out of hospital. I heard one day that one of the persons who put the bomb in my car had been captured in Mozambique. I felt overjoyed and I felt that he's put on trial. And if the evidence is insufficient to convict him and he's acquitted, that would be my soft vengeance. Because we would be living under the rule of law, and that's what we've been fighting for. And that would be more important than sending one gospel to jail, or allowing one gospel who ought to go to jail to be acquitted. Some years later, I'm sitting on the bench. I'm wearing a green robe. And I'm dealing with questions of terrorism and torture. What did this whole background experience signify to me? Now I'm in a position of power and authority. I'm representing the new constitutional order in South Africa. We have a case, it's called Kaunda, the mercenaries case. I remember we were recalled from our vacation, it was urgent. corpus package with brothers and sisters, wives and mothers and children and parents of something like 65 people who had been arrested when their plane from South Africa landed at Harare Airport in Zimbabwe as alleged mercenaries. And it appeared, and subsequently proved, they were on their way to Equatorial Guinea to overthrow, maybe kill the President of Guinea. And they were doing it for money. They weren't people from that country, they were South Africans, black and white, recruited, promised huge bonuses if they succeeded. And they're now languishing in a Harare prison, Zimbabwe prison. It was so poignant in so many ways. The families of these people called the dogs of war, on their way to kill, to maim, for money, interfering in the politics of another country, maybe a dictatorial regime, but using simply armed struggle to put their people in power, and not to install democracy. They weren't feeling fighters from the and yet their families are rushing to the Constitutional Court and relying on the Bill of Rights, the very legal order and set of principles which they were completely denied. And anybody who knows the history of Africa knows what dismay, what horror mercenaries introduced and were responsible for what magnified on our continent. And yet, their lovers, their parents, their children were human beings, terrified in terms of what could happen, and seeking the aid of the Constitutional Court of South Africa to defend it. We felt quite clearly our Bill of Rights can't extend to Zimbabwe. We can't use our Bill of Rights to protect the rights of people in another country. That's all we can do. It was at the end of the matter. I remember saying from the bench that people go into the lion's den and they're surprised to find that there's a lion there. But that was simply a sort of off-the-cuff remark. It didn't represent my legal philosophy. It was simply a comment. What to do? The evidence before us was that if they were sent to Equatorial Guinea, they could face torture. They could face execution without trial or multiple trial. Could we, as judges, just say it's outside our jurisdiction, it's not we can say do it? And we felt no. We felt that there are certain principles of international law which are universally recognized, which infuse and influence the interpretation that has to be given to our own constitution and the rights of citizens in our country. So whatever our citizens have done, they can't be excused in another country simply because they're South Africans. But they can be protected insofar as authorities can protect them from torture. There's a universal convention against torture. International law doesn't, customary international law doesn't permit torture. And customary international law has to be seen as giving a quality and a texture to the South African Constitution, which requires the authorities in South Africa to use what diplomatic means they can, have at their disposal, to prevent South Africans of war from being tortured. It is also argued that because they face capital punishment, and our Constitution has strict priors for bad capital punishment, that we should intervene in as much as we could to prevent them from facing capital punishment. But we couldn't say that international law, Pacific international law, would reach the stage yet where capital punishment violated principles of Pacific international law. A strong move in favor of abolition, but not so powerful, not so universal as to constitute a mandatory rule of Pacific international law. But the right to a fair trial was part of Pacific international law. And so we called upon, we saw it as being the duty of the South African authorities to use what diplomatic means they could to protect South African citizens abroad, whatever they might be responsible for, to protect their right to a fair trial and not to be tortured. And the mere fact that the issue was debated in public in the court probably did more to protect them from torture and being executed without a fair trial, possibly than any diplomatic means in this case. We had another case afterwards of the man called Dr. Death, who was head of the biological and chemical warfare program of the South African military in the apartheid era. And he had been charged in the High Court with a number of offences, some involving stealing money given to him for biological warfare, but also with having masterminded a program of using an asphyxiating poison against SWAPO, Southwest Africa People's Organization, Namibian freedom fighters who'd been captured. And the evidence had been that he would asphyxiate them, they'd be taken in small planes over the sea and dropped into the ocean, stopping from what had happened in Uruguay. Then the bodies are disposed of, there's no post-mortem, and it's a way of terrorizing or disappearing people. The High Court judge had decided that the South African court couldn't try somebody for planning to commit an offence in another country and refused to hear the matter. It came on appeal to us. We had to deal with the legal issue. We decided the judge was wrong, that he could have been tried and should have been tried, that he was part of the South African military who were planning in South Africa to commit murders abroad. But in any event, these constituted war crimes. There was a form of universal jurisdiction we had to respect. And in the judgment which I wrote, I ended up by saying, the mere fact, is paraphrasing that he is charged with the most terrible offences does not deny him the right to a fair trial. If anything, the more serious and the more grave the offences, the more important it was to ensure that the standards under which he was judged be impeccable, to emphasize the difference between the people who behave like that and the very values of the society that we're trying to protect. The last case I mentioned is the case of Albie. He had apparently been involved in the bombing of the American embassy in Terrorism. Terrible act. 56 people were killed in the closed intensive units. It was a form of mass murder aimed at the whole international law system itself. He came to Cape Town under an assumed name and became a pastry chef. Apparently he was a very good pastry chef, quiet. And one day when he went to have his permit renewed as political refugee, the FBI were waiting for him at his Spectre account. And within 36 hours, he's on a plane to the United States of America to face capital charges of murder in Europe. His employer couldn't understand what happened. His young pastry chef, very quiet, had just been withdrawn. When the employer suggested that legal defense be provided, he was told he's here illegally, he's got no rights, he's gone. The High Court said he'd been deported, there was nothing the court could do. He'd been correctly deported, end of matter. He came to the Constitutional Court. We unanimously decided that the procedure was unconstitutional to do this case. Firstly, he should have been allowed legal counsel. If anything, the more grave the offence, the greater the need for somebody to know what the legal rights and responsibilities are. And secondly, although his exclusion from the country could be justified, it hasn't been done in a correct way. We came across this term rendition was used. Rendition. There's a well-known way of getting somebody wanted to criminal offence out of the country. It's called extradition. And you follow due process of law and you extradite. And without doubt he would have been extradited. But that's something that you do with countries like Germany, where one of the co-accused was extradited. And in addition, the person extradited from Germany was given a guarantee. The guarantee was given to the German government that if he's put on trial and he's found guilty, he will not be executed. Because Germany, like all European countries today, doesn't recognize capital punishment as a legitimate form of dealing with people. And the judgment in South Africa, the Constitutional Court, was for the same effect. We have declared that in terms of our Constitution, capital punishment violated principles of indignity and the prohibition of cruel, inhuman degrading punishment of people and the right to life. And so, capital punishment was unconstitutional in South Africa, and to hand somebody over to face capital punishment in another country was like handing somebody over to face torture. Authorities couldn't do it like that again. We're very strong and unanimous judgment. And I should emphasize it was written with the support of all 11 judges, not just Albie, who had been in detention, who had been subject to court custody for but by Laurie Ackham, who had grown up in a privileged family, who I mentioned possibly unfairly collected wine labels, who had a deep and passionate belief in fundamental human rights, whose wife was a professor of Christian theology at the University of the Western Cape. So just to give an idea of the range of people united by the principles of the Bill of Rights, reflecting the need for transformation in our country, not only to get rid of apartheid, but to get rid of the repressive means, the agencies, instrumentalities, maintaining human domination, and that cold way of disrespecting fundamental rights of people that has been part and parcel of our authoritarian legal order. It wasn't very easy for us in South Africa. I came from Cape Town, where there was a fundamentalist Islamic group that was killing our people. They not only starting off with bombing people who said were responsible for drug dealing. But they killed a magistrate who'd been buried in one of their cases. They assassinated one of the security police investigating their affairs. A bomb had gone off at a place called Planet Hollywood, which is a waterfront in Canada. So this was real for us, how people were dying. Terrorism was on the spot, it wasn't just something that happened internationally. But we took a principled position. And in fact, that particular group responsible were detected, the activities were neutralized through good police intelligence, through clever interrogation, and in particular through the community disowning them, the community that otherwise might have supported them, given them safe houses, given them economic support, made it easy for them to operate. They were politically disowned by the very people whom they claimed to be fighting. And so that ended, and we retained the integrity of our institution. And I conclude with this thought. At the same time that those of us in South Africa who are holding operative rights on our bench were doing so, within that particular era, judges in England were called upon to deal with the question of the rights of people detained as suspected terrorists. And the court divided, but overwhelmingly in favor of saying that people have certain basic fundamental rights, whoever they are, whatever they might have done. And a person who happened to be a close friend of mine from school days, Will Hoffman, actually said, and a rather conservative person, I was the radical, he was the conservative. I loved Beethoven's Egmont Overture, and he loved Elgar's Pomp and Circumstances, and Glory. He said that more damage would be done to the way of life of British people by locking up people with that in detention without trial indefinitely than any of their activities would have done. Tony Blair was very unhappy with that particular statement. And of course, the Guantanamo Bay cases were heard in the United States of America. And again, judges who had totally different life experiences, but being confronted with similar moral, philosophical, institutional legal questions. And I felt such a sense of pride when I read the judgments of the House of Lords in England, and I read the judgments of the majority of judges, John Paul Stevens, all by the terrorists themselves, because they also counted as values that are enduring, and they endure because they are healing in between. I feel proud to be a judge in South Africa, and I feel proud to be a colleague of judges in England and judges in other states like Albie Sachs.
Time for about 15 minutes of questions. Question?
It was an honor to listen to you and hear you. My question is, it's a general saying that the violence breeds violence. In the era, and the good example the situation we have in Israel and Palestinian conflict. In that situation where there is arrogance is prevailing, what do you see how the justice could be done when there is a terrorism by state-sponsored terrorism and the terrorism of individuals? So what is the resolution? How do you see that?
That's a whole big another kind of a question. I wouldn't like to deal with it. But I would say that certain principles are universal. The issue, of course, was sharply raised by Richard Goldstein in the Goldstein report, dealing with war crimes. Not quite the same thing, but similar issues. It's been very controversial in many ways. To some extent, people respond to the Goldstein report in terms of the way they respond to the Israeli-Palestinian conflict and tension, even the way they look at the report. I find it very moving. Richard is a friend, he's a colleague of mine, he was on our board. And he's a Zionist. He's been a Zionist since he was a child. I think he continues to be a Zionist. And he also is a strong believer in fundamental human rights. And he accepted the request from the United Nations to go into the inquiry. He's a very careful investigator. He's very methodical in the way that he works. He's been criticized for including in the team at least one person who already expressed an opinion critical of the Israeli government. His response has been, this is not a court of law, it's a committee set up by the United Nations. As I say, there are some people very angry with him from the Jewish community that regard him as a traitor. There are others who regard him as a hero in the Jewish community because he felt he was doing more, if you like, to defend the dignity of Israel by holding it to account in the same way that any other country would be able to account and encouraging it to take a stand, a principled stand, in relation to its own violations. That's another whole issue. People will have different opinions on that. My own personal view is that there are standards and norms of international law, conduct that's permissible and impermissible, whether it's firing rockets against civilians into another country, whether it's torturing people in your own ranks or others who have been captured, whether it's using illicit forms of warfare that apply to everybody independently of who they are. The mere fact that your cause is good and cause is defensible doesn't mean that the methods that you use are good and not defensible.
You talk a lot about the sort of latest rule of law and this language of the war on terror. There's a real sense in a lot of American jurisprudence on this that the judges need to be particularly careful. I'm thinking of like Korematsu, and even the Supreme Court's jurisprudence on this has been, I mean, I think a lot of people would say overly cautious, and 6 years later, there are still people in Guantanamo Bay. How do you as a judge view that perspective and balance what I think is at least a common viewpoint that there is that caution that's necessary?
I can look back at many US Supreme Court decisions. I'm just quoting American authors. I don't come here to comment on my colleagues sitting on the bench. But the Dred Scott decision, justifying slavery, the Plessy and Ferguson decision, justifying separate but equal. There are always dissents. the internment of the Japanese, there was a dissent. And the dissents have become expelled afterwards. So there's been some voice heard. But they are seen ashamed for themselves. That's part of the dialectic of what's happening. The US Supreme Court, when it came to Guantanamo Bay, drew the line. It wasn't a very firm line, deeply in the sand, as far no further. It was a line that took account of the tensions involved, how far the courts could go in a particular moment, not beyond the facts of a particular case, but it was very meaningful. And I might say it was hugely important for the prestige of the American judiciary internationally and the American nation and people. Guantanamo is it's an ulcer so deep and profound to the reputation of the United States of America. And worse than that, it's justifying illegality. It's justifying abolition of the rule of law in the name of the game. And then it's just a question of which side you're on and who's the more powerful. So it's deeply unprecedented. And to the extent that this could have been justified as something outside of international law, or in principle international law, outside of the Constitution, in a kind of a limbo out there, it was enormously harmful to everything that everybody in the world tried to do for standing. I'm not saying the solution is easy. Sometimes you create a problem and the problem gets worse because you kept people for so long and you wonder what they'll do when they're released. But I'm saying the principled impossibility and ugliness of having a place like that. And it became like a symbol, like the Bastille was a symbol in France. People would use Guantanamo Bay as a symbol of, we don't want to behave like that. We don't want to be like the Americans. Does that go down well to this audience? That the United States of America becomes a standard of what we don't want to be like. Like South Africa was the country we didn't want to be like. And what's been marvelous is been to see that it's been people like yourselves and others in the United States of America, in terms of the opportunities that the democratic process allowed you, brought about the change. And that helps to restore the prestige and not only authority and legitimacy of the American government administration itself, but all of those everywhere in the world who want to maintain certain principles. Okay, last three questions.
So, we talk about international law and universal principles, but I don't think those would not be applied if it wasn't for some particularly courageous people and just citizens out there. They depend on individual countries and individual governments in order to you see any way of just the world actually uniting? Like, do you see any way of, like, you know,
Could people hear the question?
No.
Oh, okay. If the upholding of principles of international law and human rights depends on certain individuals and certain circumstances, is it possible to think about the judges of the world actually uniting? Is that a fair summary?
It's certainly relating to your question. The South African Constitution, international law is explicitly mentioned as a tool of interpretation in the process of coming to those important decisions that you mentioned. How would you describe the utility of this explicitly mentioning this as a tool? Would you come to make it a different outcome if it was mentioned?
The question is whether there is explicit mention of the incorporation of public international law in the South African Constitution and how that does or does not impact the decisions that Justice Sachs mentioned.
My question was regarding one of the last cases we talked about the men who was subject to extraordinary rendition, and then the Constitutional Court deciding that was improper, that was unconstitutional. I was just wondering about the reaction to that from the United States and what the implications are for international law. Does it turn into just sort of a political power play, or is there
question is the reaction of the United States to the South African decision regarding the extraordinary rendition case, and how does that play out in international politics?
I'll start with because I'm just regret very much now that Oxford University Press being a bit slow. They produced the most marvelous book, and I deal with some of these questions in the book. I'm doing a bit of a promo now. And I want to tell you, come next time, a bit about the blue dress and what's on the cover. You see that? But in a way, I mean, we didn't threaten the United States of America that if you don't give us a guarantee that this guy is not going to be executed, we're going to send military to take over your country. In fact, there wasn't very much in practical terms we could do. It was on trial in New York. But we sent a copy of our judgments to the court hearing the matter, and he had been found guilty. He was facing, there was a hearing on capital charge. And the question was whether our decision should even be placed before the jury. And I'm not sure exactly, I think the judge fudged that a little bit. But at least the judge was aware of what we said. And there was an incongruity that the young man from Germany had been given that guarantee. And the jury decided 7 to 5, I'm not sure what the majority was, against capital punishment. The case was actually heard in, I think it was July 2001. It had been heard in December 2001. The decision would have been the same. But the importance of the case was for our own country. We were telling our own officials, don't get all excited. Gee, the FBI are leading international stuff. You know, we're in the big league now, and we can forget about the rule of law. We were saying to our own state officials, we don't hand over people without protecting them. It doesn't mean they're immune from prosecution. They deserve to be prosecuted. You can't have people in the name of their cause going and black things. I mean, it's awful. It's horrible. It's terrible. And they're grieving families. And it's not even, it can't even be claimed to be in the course of ordinary military armed combat or anything like that. Going and diplomates doing diplomatic work, and it's killing Tanzanians who've got a job for the country. So it was, in a way, more for us. It might have helped save a person's life from execution and in serving life imprisonment as possible. The question about whether or not the significance of having a constitution that expressly requires us to apply the principles of international law. The United Kingdom doesn't have a constitution at all, but they applied the same principles. It made it a little easier for us to deal with people who are captives in another country. And there's always a toss-up between not interfering in the legal systems of other countries and respecting the difference to their legal systems on the one hand, and maintaining fundamental rights of the citizens. And this made it a little bit easier. We could employ the principles of customary international law and binding on our officials to do what they could in relation to the diplomatic means. I might say we didn't tell them what to do. It wasn't our job as judges to say whether they should send a polite note, or phone up somebody, or threaten gunboats, or sever all ties, or withdraw diplomats, whatever they do. That's their determination. But they have a duty to use whatever was reasonably within their power. We wouldn't go into it. Judges of the world unite. I say it almost out of fun. I've been trying to say you've got nothing to lose but the chains of your formality. Somehow it doesn't work. Like words of the world unite, you've nothing to lose but your chains. So if anybody can come up with a good rephrasing of that one, I'll offer you a free copy of the book. It's been wonderful for me to meet my colleagues on the bench, because I was invited for lunch at the Supreme Court. I might say the cuisine was awful. The conversation was marvelous. And I was asked by one of the judges, would I say that ours was an activist court? And I said, yes, it is an activist court, but we have an activist constitution. So that was I think I got good marks for a clever way of avoiding. As Susan said, I am one of the original intenders. And what's ironical, though, is that we don't use what we had in mind when we drafted the Constitution. We don't use that at all. It's partly so many of us had so many different things in mind. It underwent so many different drafts. They get a clause in, and then there's another clause, and the Constitution as a whole takes on a different characterization, organic quality. It's partly once it's there, it's a public document. It takes on a meaning that doesn't depend upon the subjective intention of the framers and the drafters. Our letters, what we want to have in mind. There's some phrase in that Constitution, I dropped it into the very first draft of the first Constitution. No detention without trial. Here's why. It wasn't enough simply to say everybody has the right to be brought to court within 48 hours. That's in the Constitution. That wasn't enough. That there's a basic right to freedom. No detention without trial. Explicitly there. South Africa shall be an open and democratic society. The word open. Open means a pluralistic society. A democratic society can be one where you have elections every 4 or 5 years. Sure, it's democratic. It needs to be open. It's important to emphasize the importance of openness. Diversity of views. No official dogma or religion, whether it's Christianity or Marxism or whatever it might be. No official state theory imposed upon the nation, other than what's in the Constitution, other than democracy, in the rest of the world. But that's what Albie had in mind, when the word open was put there. Now we have to give it a meaning. And we give it a meaning in terms of why we have a Constitution, or what it's never again. Never again, never again. And that explains a lot of your Bill of Rights. These were the areas where the shoe pinched, and it was a very tight shoe, pinched in a very better way, had to be guarded against. And in a way, constitutions are an extraordinary representation of the total corruptibility of human beings and the total perfectibility of human society. It's that tension between extreme skepticism and total hope, and it gets incorporated into a constitutional document to guard against the corruptibility, to promote hope, promote the possibilities of human beings. And so you have these institutions to bring about this kind of balance. And if I talk long enough, I will remember what it was I really wanted to say. Should American courts use foreign legal decisions and foreign legal materials in interpreting the American Constitution? It's a very divisive issue in the United States. And Ruth Bader Ginsburg gave what became quite a famous paper on the question, arguing for the value to be gained by United States judges, drawing on the thoughts, the ideas of judges in other countries. Not to follow what they're doing, but to help illuminate the best interpretation of the Constitution. She gave that decision in the foyer of the Constitutional Court of South Africa. She chose our court as the place to do it, partly because what we were representing. I think the majority of the US Supreme Court today just about favors the use of foreign materials, becoming more and more done. As I say, not to get precedent, not to follow, not to say one American Supreme Court decision is worth 2 Canadian, 3 German, and 4 Namibian, and 5 South African. It's that philosophy, it's the ideas, it's the values, that value system. So it's the values of human rights, of rule of law, respect for human dignity. These are the values that the judges throughout the world I would like to see uniting around. And if you can encapsulate that into a nice phrase, judges will unite, you've got nothing to lose but you get a free copy.